Hello and good day, everyone. This is to welcome you to the 11th edition of Legal Insight. Today is Saturday, the 4th day of April 2026. In this edition of the program, we'll be paying attention to duties and obligations of directors. If you could recall, in the previous edition of the program, we have already defined who is a director, the types of directors, and their mode of appointment. So in continuation of that discussion, today we'll be looking at what are the duties, what are the responsibilities, what are the obligations, and what are the liabilities of directors of a company. Directors through the board are central in the administration of company. That is why the law places certain responsibilities on directors. And one of the most important duties of directors is fiduciary duty. A director stands in a fiduciary relationship towards the company, and it is expected that he will observe utmost good faith in any transaction for or on behalf of a company. Now, a director can be said to be in breach of this fiduciary duty where he fails to act in the best interest of the company, or where he fails to observe utmost good faith, or where he abuses his position for personal gain. For instance, where a director awards a contract to a company owned by his wife at an inflated price, such will amount to breach of fiduciary duty. Or where a contract is awarded to a company where such directors has interest without following the due process of procurement laid down in the company, such will also amount to breach of fiduciary duty by such director. When it comes to voting during board meetings, a director is under obligation to make an independent decision. What this means is that a director is prohibited from making advance promise of voting in a particular way. For instance, a director cannot promise board chairman that he will always be in support of his position. A director is prohibited from doing that. He has to make his independent decision based on facts and circumstances available. Another duty of director is duty to always act in the best interest of the company so as to preserve the asset of the company, promote its business or object for which the company is formed, in such a manner that a skillful, diligent, and faithful director will also act in the circumstances. This means that in order to determine whether the action you took as a director are in the best interest of the company, an objective test will be applied to see if a faithful, diligent, and skillful director will have also acted in the same manner as you have acted as a director of a company. Directors are under a duty to avoid conflict of interest. It will amount to a conflict of interest if a director, in the course of management of the affairs of the company or in the course of utilizing assets of the company, is making secret profit. Another duty of director is a duty not to misuse corporate information. I think it will amount to a serious misuse of corporate information where a director in company A is feeding company B with secret information regarding the trade secret of company A. The last but not the least of the duties of directors we are going to consider in this edition is the duty to make disclosure of interest regarding contracts. Where a director has any interest in any transaction or proposed transaction involving the company, it is mandatory on the director to declare such interest in writing, specifying the nature of the interest to the company. Failure to make such disclosure will amount to breach of this duty. In conclusion, where a director breaches any of the foregoing duties, the company can maintain civil action against him, and in some cases, a criminal proceedings can also be maintained against such directors. So it is important that directors of companies know their duties under the law and discharge such duties appropriately. Now, this brings us to the conclusion of this edition of Legal Insight. If you find this edition interesting, stay tuned for other interesting edition, and thank you for watching.